What's up, everybody? Hopefully tonight was worth the wait as we have an expert, in quotes, get destroyed on cross-examination like I haven't seen even in this trial. And we're going to talk about why it was such a big deal and why it was almost should have been so much easier for the Commonwealth to do this the right way. And they just dropped the ball and the defense just hit a home run with it. And then we're going to hear from an expert that I thought did a much better job. And some people may disagree with me on that, but I think he did a much better job. And neither of the experts had a lot of education. We'll talk about why that's different. And as a lawyer, why I see it differently. I want to hear as a juror how you may or may not see it differently. And then we finish with some text messages that I heard rumblings from. These are going to be bombshells. These are going to be Karen Reed's undoing. I've been waiting for these text messages all trial. I couldn't believe they saved them to the end. And I'm going to give you my thoughts on those. I'm going to answer all your questions. Here we go. So I'm going to start off just to get people riled up in the chat. I hope the Mavericks extend the series tonight, just because if it's not my team, I want more finals basketball, right? I just want more. I want more of the competition, more of the juice. Hopefully we get to watch the end of it. But we've got a lot to talk about today, and it was a really interesting day from my perspective because there were multiple experts, and I saw objections to them, and I get it. And I'm one that talks about you got to have education, you got to have expertise, you've got to be good at communicating information as an expert. It's all really important. And neither of these first two experts really had much education, but there was a major difference in how they testified and what they know and what they portrayed their knowledge to be, in my opinion. Now, what they were potentially trying to prove, one was much more important than the other. And we'll dig through all of that today. But to start off, I want to play basically the end of Officer Paul's testimony. And I think we're going to play at least three times his opinions in this case. And this expert is an accident reconstructionist. He is the expert that they have called so far. I don't know if there's another one. He is the one they've called so far to explain how this accident happened, how the car moved, how John O'Keefe's body moved, how it all lines up and matches up with the car data and where everything's plotted at the incident scene. He is the one they have called to connect all of these dots. We've heard a lot of foundation laid. We've heard where a lot of evidence was gathered from, what a lot of cops did. This was the key witness. This and the medical examiners who I've been waiting for the whole time to explain how the injuries correlate and how his death was caused by a car. By the way, the medical examiner saying it was not a homicide, but that was undetermined, doesn't necessarily mean the medical examiner is not going to get up and testify that he was killed by blunt force trauma, likely from a motor vehicle, right? They may have that opinion. I don't know. I haven't read it. I haven't heard it. I've tried not to. I don't know why they're going to, or what the medical examiner is going to say. We know they're going to say undetermined as far as homicide. At least that's what we think so far. But that doesn't mean it's going to all be bad for the Commonwealth. Same thing with the reconstructionist. Yes, the gathering of the evidence. Yes, there were issues with that. Yes, they're going to call conflict of interest. But if this guy could tie it all together, that could be huge for the Commonwealth. But we need this to make sense beyond a reasonable doubt. We need it to be reliable. We need it to be credible. We need to think there's no really other explanation. There's no other reasonable explanation for what happened, because that would be a reasonable doubt. The state's got to prove it. Defense doesn't have to prove their theory. Okay, I get it. And people, are starting to get a little confused, I think, with that. And partially, I think it's because of how the defense is presenting it. But let's listen to Trooper Paul's basically summary of his opinion. This is the end. And he blows it right off the bat because he wants to read it out of his report, which he's not allowed to do. He tries multiple times to read it. But eventually, we do get to what his opinion is.
We continue.
If you could, please. Okay. What, if any, conclusions did you come to through the course of your investigation?
So on Saturday, January 29th, 2022, at approximately 12:45.
So you can look at your report, but you can't read your report.
I read my conclusions based on what they asked me to do.
Okay.
Yeah. So I can't hear you.
Sorry.
Okay. So just take your time, read your report, and then answer Mr. Lally's question. And if you need to look at your report, we'll see about that again.
All right.
Ask the question, Mr. Lally.
Based on the totality of your investigation, what, if any, conclusions did you come with regard to how this collision occurred.
So this collision occurred on Saturday, January 29, 2022 at approximately 12:45 hours. A 2021 Lexus LX570 was traveling southbound on Fairview Road, in Area 34 Fairview Road.
Yeah.
It appears that.
So,
I'm trying to hold it.
you know what? I don't, Mr. Lally, break this down. Ask simple questions so that the witness can answer your questions. We don't need a
Then it kind of makes Lally look bad because she's like, break it down. This guy cannot just read from his report. He needs to tell the jury and be able to testify to the jury what are his conclusions. And it's problematic, especially when he said he studied, and I think he said he memorized his report basically before his testimony, and he can't even give us what his conclusions are, which to me, I will just tell you what that says to me. Every single person will see this differently, especially, you guys that are potential jurors. I get it. As a lawyer, this to me tells me it does not make sense. If he studied his report and he was like, it was going this fast on this road, and we could tell by the skid marks, or we can tell by the car data and where his body landed and where it hit, it was this many inches up, and it all kind of comes together, which other witnesses have testified to. And we're going to hear one kind of tie it all together in his conclusion at the end. That's not what this witness did. And that's not good. If you can't tie it all together in a bow in like a couple sentences, it's going to be hard for the jury to be able to do that. And you want the jury to go back there and say, this is what happened, exactly what Mr. Paul said.
narrative.
From your investigation, what, if any, conclusions did you come to as to where this collision occurred?
All right. So on the night of Saturday, January 2022, at approximately 12:45 hours, a 2021 Lexus LX570. So yes.
So forget all that part,
Okay.
Trooper.
All
Just
right.
answer the question.
Okay.
Where did it occur?
It occurred in the area.
She's like, he asked you where it occurred. He didn't ask you what date. He didn't ask you what kind of car. He just asked you where it occurred. Don't regurgitate your report exactly.
34 Fairview Road.
And who, if anyone, were the participants in this collision scene?
The operator appeared to be Karen Reed, and the pedestrian was John O'Keefe.
So the operator appeared to be Karen Reed. Where did he get that from? Right? I'm not positive where he got any of this information. And when Jackson asks him on cross, he doesn't seem to remember who told him what. So if he can't remember that, I don't think he should be able to testify to it. But the judge allowed him to. But he says, yeah, the operator was Karen Reed. We know it was her car, but I don't know. Like, where did he get all of the stuff for the time that the incident actually happened? Experts can get it from other people, but usually we have to know where it came from to be able to test it.
And where was the vehicle located in reference to the residence of 34 Fairview?
It was located along the southbound travel lane and to the left side of the house as you look at it from the front.
And as far as the vehicle, what, if any, directionality did it head in, and what, if any, interaction did it have with Mr. O'Keefe?
So the vehicle was traveling in reverse along the southbound travel lane, traveling north.
And how fast was the vehicle traveling and over what distance?
The vehicle traveled up to 24 miles per hour and approximately 62 feet.
And at the time that the vehicle was traveling,
So
approximately.
just think about that. Let's just think about the numbers that he seems to be confident in. Okay. 24 miles an hour and 62 feet. That gives you some numbers to start with. And if you're an expert, you can work this stuff, right? 62 feet, 24 miles an hour. We know where the body landed. We know where the pieces of plastic were. You should be able to reconstruct this. She started here. She ended here. His body flew this far. The pieces shattered and they flew this far. And that makes sense because when it shatters, they go in this direction. I'm making it up. But this is what experts do. They take measurements. They explain the force in which her SUV, it's 7,000 pounds or whatever. So a 7,000 pound vehicle driving 24 miles an hour could easily do this amount of damage. The force calculation equals this, something that sounds really smart. That's enough to drive through a wall, whatever. I've had experts give explanations like that. People were asking, is 24 miles an hour fast enough to kill somebody? Absolutely. I have had motor vehicle death accidents of less than 15 miles an hour. The slowest one was a child, but I mean, this stuff, you do not have to drive very fast with a 7,000 pound vehicle to kill somebody. You don't want to know what the injuries looked like on that kid. There was absolutely no doubt it was from blunt force trauma from a Ford Expedition, the front of a Ford Expedition. Absolutely no doubt. So convince the jury that this was a motor vehicle collision. How big the car was, how fast it was going, how far it went, and how, because of that force, somebody that weighs 220 pounds would likely, based on my equation, fly 30 feet or whatever it ends up being. The defense is, of course, going to be like, so somebody flew 30 feet. Wow. And he can say, yes, based on my equation, 30 feet is right into the variable distance that somebody could fly or roll or tumble or be thrown from being hit from a vehicle. That's how experts put it together. Mass times velocity. Right. I don't know what the equations are. I'm not an accident reconstructionist, but like, you should be able to figure this stuff out. How much does the glass weigh? What do you expect it to fly? What about a shoe? Like, you should be able to calculate those numbers and at least give a range of what you would expect to happen. Just because it was a side swipe, like, so then you just can't do anything. That's basically what he said. I mean, it's wild. Sorry, I keep interrupting him. Let's get what his actual opinion is, because it's not any of that.
24 miles per hour over approximately 62 feet. What, if anything, occurred then?
The right rear of the Lexus struck the pedestrian John O'Keefe.
And post-collision, what, if anything, occurred with regard to Mr. O'Keefe?
Mr. O'Keefe was projected forward and to the left along the front yard of 34 Fairview Road.
And post-collision with Mr. O'Keefe, what, if anything, the defendant's vehicle?
The Lexus continued traveling in reverse before they left the area.
Now, as far as the vehicle itself, from your inspection, what, if any, role did any mechanical aspects of the vehicle play in this collision?
There were no mechanical defects.
So this is a thing because a lot of times in either DUIs or intentional vehicular homicide type cases, they'll blame the brakes failed or the steering wheel messed up. I tried to steer away and it wasn't working. I think even Daryl Brooks said something like that. So they'll always check it for mechanical failures and they'll confirm that there were no mechanical failures. That's why there was a lot of discussion about that. Doesn't really have anything to do with this case. The defense hasn't claimed that. Maybe they would have if there was, but there wasn't and they didn't.
Your analysis of the roadway and other factors related to that, what, if any, role did they play in this collision sequence?
There were no roadway or environmental factors that contributed to this collision.
Sir, with respect to your investigation,
There was no roadway factors attributable to this collision. So the snow didn't matter, ice didn't matter, you know, how cold it was. They talked about the frozen ground. Lally tries to get in there. None of that came into play for his analysis.
what, if any, opinions did you draw based on your training experience in regard to this collision and how it occurred?
May I look at my report real quick, just to make sure?
Yes.
Thank you. All right. So throughout my investigation, this appeared to be a single car collision involving a pedestrian. The vehicle was traveling at a higher acceleration.
He had to look at his report to say this. Remember that. He had to look at his report to give this part of the testimony.
When
legitimately, I do feel bad for him. Partially, I feel really bad for him because I think he's really nervous today, more nervous than yesterday. But tell them you can't testify to this stuff. Like, just tell them you can't testify to this stuff if you can't testify to this stuff. Stuff being the operative word.
the vehicle accelerated at a high rate of speed before she struck the pedestrian John O'Keefe on the roadway and subsequently left him at the scene.
And with respect to the backup safety system that you observed in this vehicle and made use of the course of your visibility analysis, what, if any, role do you, is it your opinion that played in how this crash occurred?
Based on the visibility analysis. So even if the camera systems were covered in snow, even if the systems were defective anyway, and even if the mirrors were blocked, an attentive and a reasonable operator would not travel in reverse, especially at a high rate of speed. They would have cleaned the mirrors off. They would have made the cameras and systems, if they worked, they didn't work. They would have done all this prior to accelerating in reverse.
The objection sustained.
So a reasonable, careful, either non-drunk or not intentionally trying to hurt somebody driver would have made sure all that stuff was working, made sure they could have seen behind them. They wouldn't have backed up and hit somebody. Okay. So now he's getting into her mind. He's trying to prove intent. More on that later, but he's trying to prove intent with how somebody backed up going that fast and then left.
Move to strike.
I'm going to strike that.
With respect to your observations during the course of the visibility analysis, the exemplar pedestrian that you placed in the right rear of the vehicle, was that exemplar pedestrian visible to you at the time that you conducted that visibility analysis?
Yes, it was.
Thank you, sir. I have no further questions.
Okay. Cross-examine.
All right. So Matthew said, why can't they read from their report? What is bad about that? So expert reports don't come into evidence. They're filled with hearsay. And the point of the expert is supposed to be able to testify to aid the jury in something that they can't understand on their own using their expertise. So that's part of it. You've got to tell what your opinion is and why. You can't just type out a report and read it. It's filled with hearsay. It's backed up with hearsay. It really doesn't make sense without hearsay. You are allowed to use that and come into your opinion. But in most courtrooms and most jurisdictions, it never comes in because it is, in fact, inadmissible.
Explanation?
Thank you, Your Honor.
So here's the beginning of cross, okay? So I wrote a tweet, and it's funny in this case how tweets get handled, but I wrote a tweet that when I said Yannetti should be careful with the prior cell phone expert because she was smart, you got to be careful about arguing her with things like this. She's going to be able to, even if she doesn't know, she's going to be able to make it sound better than any of your questions are going to be. So you have to be careful with witnesses like that. This guy, on the other hand, is the opposite. I legitimately, you guys know, I always say, defer to the expert. Don't try to fight with the experts on their expertise. I legitimately think I won't use myself. I think Alan Jackson knows more about accident reconstruction than this expert. And when that's the case, it's not good for the expert because we're also lawyers and we know how to use words and ask questions that are going to highlight your deficiencies. And Alan Jackson comes out swinging against this guy. This guy takes a sip. Again, I feel bad, but this is how it works. This is how the playing field is even. You can't just have cops get up there in grand jury proceedings and say anything like this guy did to get charges thrown on somebody. You don't have a lawyer in those grand jury proceedings. But guess what? You get a lawyer now. And this is the difference when you have a defense lawyer versus when you don't. And the grand jury almost always says, sure, go forward on charges. But the jury doesn't always convict.
So do you hold any degrees in the scientific discipline of mathematics?
I do not.
Do you hold any degrees in the scientific discipline of physics?
I do not.
Do you hold any degrees in the scientific discipline of biomechanics?
No.
How about in engineering?
No.
How about in kinematics?
No.
The highest degree that you do hold, sir?
I have an associate's degree.
In what?
Administration of justice.
Okay, now I'm not here to make fun of anybody for any degrees or anything like that or lack thereof. But what I will say is, and I don't think that's what Jackson was doing. I think what he was doing is, I would be willing to guess, and I don't know. You guys know. I don't know this. I think we might find out tomorrow during voir dire. But my guess is his experts hold degrees in all of those specialties, which give them the expertise necessary to do the calculations and explain to the jury physics, how things move, how forces work, and what is reasonable based on all the information that we have. And if you don't have those degrees, you are less credible. Doesn't mean you're lying. It just means you don't understand as well, or you don't have the ability to get the answer as well as somebody who does have those degrees and has studied and focused on that. Not an AA in the administration of justice, which is great for a cop, but not a expert witness in reconstruction.
You mentioned kinematics on Friday. Do you hold any certificates in the specific area of kinematics?
Yes, it's covered in the basic crash investigation classes.
Okay, so you took a class, in other words, correct?
Multiple classes.
You introduced the idea of what kinematics is, right?
Correct.
Testified about that on Friday.
Yes.
Define kinematics, George.
It deals with the aspect of motion.
It's a subfield of what broader field?
Kinematics.
Clear he's trying to ask him questions he doesn't know the answer to. It's very clear. That's exactly what he's trying to do. He's not testing him. He's trying to ask questions to make this guy say, I don't know. And unfortunately, he does say, I don't know multiple times. Yeah, Amy Z, it was not a good watch. It was not a good watch. It was tough.
Kinematics is a subfield of what broader discipline of science?
I'm not sure.
Physics, correct?
Yes.
And it describes how points and objects, systems of objects, how they move, and how the rate they move and the rate of their velocity, correct?
It deals with the motions.
What's that called? The rate of
So at this point, I think the expert would say yes to just about anything Jackson said.
velocity. What's another word for that?
The rate of velocity?
Right.
I mean, it deals with the motion. It deals with forward and also deals with speed. It deals with travel and speed. If something's moving, it also has a speed to it.
Right. The word you're looking for is acceleration, correct?
Sure.
What role does acceleration play in the field of kinematics?
What role does acceleration play within kinematics?
Right.
It talks about, like you just said, it talks about the speed and talks about motion.
Is kinematics also known as the geometry of motion? Is that correct?
I have not heard that.
Never heard that. What's the difference between constrained and unconstrained motion?
Constrained and unconstrained motion?
That's what I asked.
Constrained motion. I can't recollect at the moment.
Constrained motion is motion on a predetermined path, isn't it?
Yes.
Unconstrained motion is what?
When it doesn't have a predetermined path?
Free movement, right?
Correct.
So you remember that from your class?
For the most part, don't go that constrained and unconstrained.
Constrained and unconstrained, not restrained.
Sorry, unconstrained. Yes.
kinematics uses algebraic formula to model these motions, right? Motions of these points, systems of points, correct?
Yes.
And it includes concepts like displacement and speed, velocity, distance, acceleration, which we've talked about, correct?
Correct.
And it looks at how these things, these values vary over a point in time or duration in time. Is that right? Do
Yes.
you actually understand the physics behind the study of kinematics?
Yes.
What you learned in class?
Yes, we had to go over the physics part of it.
On Friday, you said that this incident is a pedestrian strike from the vehicle. You reiterated that again this morning. Is that right?
Correct.
I want to be clear. That is your opinion based on your training and experience, correct?
Yes.
And on Friday, you said you based that opinion on the fact that you noted a half-mile-an-hour decrease in speed and a steering input of less than 10 degrees at some point in that reverse motion, correct?
I said it was consistent. That data point in general was consistent with something that you would see within data of a pedestrian striker striking something else. I do go on my report saying I can't say that's definitively where a pedestrian was struck, but
I'm sorry.
it wasn't definitively. Sorry, in my report, I do say I can't say that is definitively where the pedestrian struck.
You cannot say this.
Definitively, yes.
Okay, so you're going to have to slow down and speak up, okay?
You said, I just want to make sure I'm hearing you correctly, and I apologize.
Okay.
You said you cannot say definitively that that resulted in a pedestrian strike.
That data points within the text stream data is what I'm talking about.
Okay.
That specific points, that time frame.
Because there's a multitude of reasons why when someone is driving in reverse, they might slow down by half a mile an hour, right?
It's when I say when it's consistent, is because there's the other aspects of it is the fact that the accelerator is consistently strong.
Let him answer. Finish your answer.
So the accelerator is consistent at a constant rate, and then it just drops by half a mile, and the steering wheel all of a sudden abruptly goes to the right. That's what I'm talking about when I say it is consistent with a pedestrian strike. That's something that you would see. It's not going to be a huge change of speed during this collision.
It could be like 100 things, right? That's the problem, is just slowing down a little bit, even if the foot remained on the pedal, and turning the wheel a little bit to the right. That could literally be 100 things, right? It could just be drunk driving too, right? I'm not saying she was, I'm not saying she wasn't, but it could be 100 things, including, but not limited to, a pedestrian strike. We're trying to prove this beyond a reasonable doubt. K-Rab said, in my opinion, Proctor told him what he thought happened, and this guy made the data fit that conclusion. He is young and experienced, undereducated, and easily swayed by stronger personalities, including Jackson and Proctor. So what's interesting about this K-Rab is, I was going to say when we get to the end of Cross, I loved the beginning of Jackson's Cross. I thought it was really powerful. I didn't love the end, but the end may stick with people kind of like it did with you, because what did he say at the end? Proctor told you this, didn't he? Proctor wanted you to make sure it fit into his narrative, didn't he? And maybe some of the jurors are going to think that. I didn't think it was that strong of an ending when he said basically Proctor told you to do all this. But
also note that at the time, it had begun to snow, correct?
Yes.
Be snow on the lawn, right?
Correct.
Snow on the cars.
Yes.
Snow on the trees.
Yes.
Snow on the roadway.
Yes.
Snow on the roadway could impact how tires move over the roadway, correct?
In a way.
And obviously, there are a multitude of reasons why somebody might input a 10-degree input on a steering wheel, right?
Correct. That's why I can definitely say it.
Right. So every time somebody slows down, going in reverse or forward, and introduces a 10-degree input on the steering wheel, doesn't mean they're looking to hit a pedestrian, correct?
Correct.
You testified that you determined the area of impact by basically following, if I heard your testimony correctly, basically following the debris field from the body from where you believed John O'Keefe's body's final resting place was, almost linearly to the furthermost piece of debris that was found. Did I get that right?
Yes.
In other words, you established what...
he confirms yes to that. And then Jackson goes into that a piece of debris was actually found by the fire hydrant, which makes no sense because debris wouldn't fly backwards. And then he says, well, that's not really how I did it. I don't have a specific point of impact. It's more of an area. It's not exact. I just take a line from where the body is. I draw it straight out to the road. Like the most imprecise, unscientific thing ever. Beast told me this, and so did K-Rab. That is very unfortunate for this witness. Because that means not only does Jackson know this stuff just from being a lawyer and maybe handling other cases with accident reconstructionists and having his own expert that can help prepare him for cross of this expert, but he may have some knowledge himself, and that's dangerous. That's dangerous. Okay. So what else we got? All right. So yeah, let's hear him explain kind of that point of road. Because again, I want to give this guy, he's the expert. I want to have him explain exactly why he thinks it happened the way that he did, that this is the state's case, in my opinion. This guy is the state's proof that Karen Reed hit John O'Keefe with her car, and that is how he died. And she did it intentionally.
Oh, stop jumping around just a second. I think we
Okay.
just get back to 587. Oh, sorry, the diagram. Okay. Now, seeing what we just now seen in terms of that piece of plastic that appears to be from the taillight, does that appear to be under the fire hydrant, which is highlighted? Same piece.
Yes.
Okay. Based on that, does that change your opinion? Is that now the fire hydrant now point of impact?
No.
Where's the point of impact now?
It's along the roadway. I don't know the exact point of impact.
So you don't know the area of impact.
I said the area of impact is along the roadway after the debrief.
Okay.
I mean, only thing it would change is maybe it was a little further away. But besides that, it's a linear field. I'm not talking about like one point. You kind of follow the middle of the debris field, and that should be the path.
Well, if the point of impact is along the roadway, where along the roadway, you can show the jurors where along the roadway in your expert opinion was the point of impact.
It should be.
He's got to have, like, your answer to this has to be within 3 feet right here, something. It could be wrong, and maybe they'll have something to say like, well, no, because this piece is here. And he's like, it's not a perfect science, but based on where the body was, based on where the broken pieces was, based on we know she traveled 62 feet. If she started here, they said that, they saw her car by the flagpole. I'm just making this up because I don't know how long it is. 62 feet back from the flagpole would be here. Now, maybe none of that works. And if none of the numbers add up and the math isn't mathing, well, then you got a problem. And then I understand why your testimony is this way. But a good accident reconstructionist will use the numbers to create the story and create the opinion, and then work backwards with every question. And every question has an answer in the equation.
Be within, if you follow from pedestrian's final rest here, just kind of follow back. That's what I'm talking about, linear field.
And I'll tell you what I don't want any of my experts ever doing is using words like kinda and stuff and I don't want my experts using that verbiage. I don't.
I can.
So now you've indicated an area. I can follow your laser pointer, an area along here, correct?
Yes, somewhere in there.
All right. If I have my spotlight, is that, if I leave it right there, is that about where the middle of the spotlight, about where you believe the area of impact is?
It's within, I guess you can say it's within that area. I don't know. Definitely, there's nothing on the roadway that has a definitive point that says this is the area impact right here. It's within the roadway based on the evidence at the scene.
Okay. Mr. Paul, sorry, Trooper Paul, I'm asking you, based on your expert opinion and your conclusions, based on your full analysis, can you point me to within an area of 5 feet or so on the roadway where you believe the area of impact is? Is my
Jackson knows that's how it's done. He even said, I missed this the first time around. Can you point me with even like a 5-foot area of where this is? And I think Jackson knows the numbers don't match up. So wherever he picks is not going to make sense. So maybe this expert thinks like, maybe if I just don't pick a spot, they can't disprove it.
spotlight basically highlighting the area that you believe, in your opinion, is the area of impact?
Do you have that laser pointer?
I do.
Why don't we let him show you? It'd be easier for the jury to see.
The guy's like, come on, Bev, why are you doing that to me? I don't know where it was. And now you're going to make me point it out?
So what I'm trying to say is, so we follow the linear path back around this area.
Can you,
And sorry, I'm trying to keep it straight as much as I can. Follow back to here. I can't say like if this definitely is, but it's possibly based on also vehicle damage to the back of the vehicle. So if you follow back to here, that could be a possible area impact.
so when you say that area there, I want to be very clear for the record that what you highlighted is an area basically just to the left of an X that's on the roadway, on the bottom of diagram 3, toward the lower part of diagram 3.
It's
correct.
You would use your circle almost kind of be a good area around.
Sorry.
You can use a circle around here. This would be around the area.
Okay.
Okay.
So using your scale, that scale is going from full left to full right. It's plus or minus 40 feet, right?
Which can't see it. So say again. Say the question.
That scale is 40 feet. Going full left, full right, 40 feet.
It's 40 feet. It's a 10-foot scale.
Okay, sorry, 20 feet. My mistake.
That was okay.
As observed. 20 feet. Thank you. All right. So if you use that scale, can you estimate for the jurors? I'm just going to use this X as a starting point. You estimate for the jurors from this X that I've highlighted. The pedestrian's final rest. What's that number? Doesn't have to be exact. Give me an estimate.
So I mean, it could be within 30 feet because also on my scale, this 2 and 3 is 50 feet from each other.
It's how much?
50.
50.
50.
So would you agree that from this X down here,
So now we have another number. Every number should be helpful to these, engineers and mathematicians. Now we have 30 feet from the point of impact is where the body went. You should be able to work backwards in your equation. 7,000 pounds, 62 feet, 24 miles an hour. Would it throw a 220-pound person, whether it was rolling or through the air? And by the way, you can use that. If through the air it would go farther, you can say, well, then he must have rolled because if he would have flown in the air, it would have gone, X amount of feet. All this stuff is usually used by experts.
So pedestrian's final rest. That's profiles. That's probably a good 35, 40 feet.
I mean, I could try to use the scale. Use me as a scale.
If you wouldn't mind. Can you use paper?
Yes, please.
With permission?
Okay.
Just blank piece of paper.
Feet.
We're up approximately 30 feet.
Still around, it's approximately 30 feet.
We're up approximately 30 feet.
Yes.
Can you place, with the court's permission, can you estimate 30 feet in here?
Can I ask?
Can you point to a place in the courtroom that looks like it's 30 feet from you?
Objection.
No. Next question.
Jessica said, as someone who's probably heard a lot of accident reconstructionists, how bad was this for you? Scale of 1 to 10. This was a 1. Like, I honestly don't think if I tried to put this guy up, that a court here would let me say he was an accident reconstructionist. I don't think he would be allowed to make this opinion in my trials. Honestly, I don't believe he would be able to. Layla said, I find it interesting. Many have been waiting to hear how this happened. This guy testifies. Does the state choose the reconstructionist or are they blessed with one? He does not sound like an expert. So he is a cop. And that's one of the reasons, cops are allowed to do stuff normal people aren't. But the state can absolutely hire a private company to do an accident reconstruction. They don't always. They're supposed to train cops to be good at this stuff. And I've seen some cops do a good job. I've seen some cops in that same parking lot death case. There was a accident reconstructionist cop that totally blew it. All of her measurements were wrong. And we talked about it on when I deposed her very nicely. And she didn't do it on purpose. She felt bad for the person that hit the kid and didn't give him a ticket. It's a long story, but it was horrible. It was very bad, but at least she had numbers and calculations and equations. They were just wrong. This guy didn't even do that. So I've seen some bad ones, but this is really bad. And the state, just like they hired these cell phone outside people, some of them, they're allowed to do this. Reed, if KR's Lexus was not paid off, did she have to continue to make payments after it was seized? It's a good question. Yeah. I mean, if she wants to keep owning it, then she has to keep making payments on it. And they don't usually seize it forever. Like she'll get it back after the case if she's found not guilty. Usually, I guess I don't know what it is in Massachusetts. When there are expert witnesses who are this shaky, how on earth do they survive a Brady-Daubert analysis? Is the bar really that low? Thank you. The bar is definitely lower for cops. I'll just say that. Definitely lower for cops. It's not supposed to be. Steve's beyond repair. So you're going to sit there and tell me she sideswiped John's forearm, destroyed the taillight, sending parts back into the fire hydrant, and John, while holding his drink and phone, flies back 25 feet, landing on his back. We're going to touch on some of these details because even his own explanation with this just doesn't make sense. Kaleidoscope said, where does the 62 feet come in? Was that confirmed with the car data? He said yes. He said yes.
Does the court have a diagram of the diagram of distances?
In this courtroom? No.
You indicated just now, and then I'm finished with this. Thank you. Thanks. You indicated just now in answer to Mr. Lowry's last couple of questions that in your expert opinion, when the SUV struck pedestrian John O'Keefe, he was, quote, projected forward and to the left from the front yard to his final place of rest.
Yes.
So your expert testimony is that John O'Keefe was hit with the SUV and flew 30 feet.
Projected mean like I don't think he flew all the way there. He was projected in that way. He got pushed forward in that direction.
Which he was rendered incapacitated, landed there, that's sort of fly there, right? Didn't walk there.
I mean, was he definitely flying like literally off the ground the whole entire time? Or
Well, you tell me, you're the expert.
I mean, when we say projected, he gets projected and they usually have a landing phase and they land and they either roll or tumble to final rest.
Okay, how far do you think he landed? How far was it until he landed of that 30 feet?
I don't know. There's no indication of where his exact landing spot was.
Was there any evidence whatsoever that he landed and rolled?
And there was no evidence that he landed or rolled. Or no, rolled.
This is important stuff here. There was no evidence he landed and rolled. So right now, if the jury's paying attention, Jackson is crossing off reasonable explanations for how he could have died, how he could have hit his head. There's no evidence he landed and rolled. There's no evidence he flew through the air. So what happened?
Rolled.
According to you, the evidence that you have in front of you is that you get hit, fly 30 feet, land where he ended up in his final rest, right?
Objection.
Sustained. Ask it differently.
Based on your expert opinion, you believe that he was projected through the air to his final rest place.
That's not what I'm saying.
But you said there's no evidence that he rolled.
And there's no evidence that he flew through the air either.
Exactly.
Exactly. So those comments, while inappropriate potentially, and the judge keeps telling him to stop, it gets the jury to listen. So now we have confirmed from the Commonwealth's expert that there's no evidence he rolled and no evidence he flew through the air.
Right? Exactly.
Objection.
Sustained.
He did it a second time.
You said on Friday that in your experience, people tend to lose objects that are not strapped to them. Is that right?
Yes.
In other words, get hit by something, car, truck, bus, whatever, train.
So this is where he gets into how did he keep the cup but not the shoe?
And if you have something in your hand, boom, you lose it, you drop it. If it's not strapped to you, correct?
Correct.
How do you suppose that Mr. O'Keefe, in your opinion, held on to that glass cup that was found right next to him over the course of 30 feet being projected?
Objection.
I'll allow it. Do you have a theory on that?
I don't know. I mean, it just could have been with him the whole way. I don't know. I wasn't there, so I don't know how the glass stayed with his body and went with him to the final rest.
So it's just common sense. You have to believe it. So it was in his hand and held onto it the entire time it was being protected. Right?
It could have been his hand. It could have been tucked next to his clothing.
Did you say tucked in?
So now he's going to make another mistake. He's going to say the cup could have been in his hand. It could have been tucked in his clothing, which is all true. And that's fine. And he can say that. There's a lot of possibilities of where the cup was. But when he already explained once, and when he's going to explain with Lally again on redirect, I believe, he says how he thinks the accident happened is O'Keefe was holding up the cup and, got hit here, and his hand holding the cup made the dent on the Lexus. So if you're going to say his hand is holding the cup, you can't say maybe the cup was everywhere else.
I mean, could have been next to his body. So when he projected, made the glass was with his body as it was also flying. So there's a number of reasons why the glass also got projected with the body while he was holding it.
I thought you said on Friday, you disagreed with me that people drop things and they're hit.
Yes, but I think not everything it tends to fly off. I mean, some stuff flies off, some stuff will stay on. It's not uncommon to find a piece of clothing and stuff, that you find at the scene.
Piece of clothing?
Like clothing, like shoes, like shoes and stuff like that to come off the body during a pedestrian crash.
Well, that's not what I asked.
I know, I'm just saying, you asked me, you said about this. I'm just responding to what you said. I'm trying to make sure you understand what I'm saying.
No, I don't, but I'll ask another question. Shoes are strapped on by definition, right?
Yes, but it's very common for shoes to come off.
How about a cell phone?
Cell phone, yeah. Yeah, it depends, depending on where it is.
Well, it was under his body.
Okay.
How do you account for that? He held onto a cell phone with one hand and held onto a cup with the other.
Objection.
Sustained. Ask it differently.
If the cell phone was found under his torso, under his body, what's your theory on how that cell phone ended up flying 30 feet with him?
It just did.
Just did. And somehow, as he landed,
Just did. He has no explanation for how the cell phone ended up under his body, Teresa. That's the answer.
tucked that cell phone underneath his body to land it on top of it.
It just did. That's the evidence at the scene. I didn't put the evidence there. So
Well, you didn't.
objection.
All right, so
Jackson's like, he's like, I didn't put the evidence there. I don't know how it got there. He's like, well, you didn't, is what Jackson's saying. And of course, admonishment coming from the judge.
jurors, I've told you before, lawyers cannot make comments, so disregard it. Mr. Jackson, don't do it
I
again.
understand. So
You understand, but don't do it. Your answer is always, I understand. Don't do it.
Yes, Your Honor. Tell me
My
more.
opinion, a worthy admonishment by the judge. That's inappropriate. He does keep saying he's understanding. He does keep towing the line. That was not overstepping by the judge. You don't do stuff like that if you don't want to get admonished in front of the jury. I don't think he cares. I think he knows, and the jury knows. He's pissed. He thinks this stuff is BS, and he thinks everybody's trying to set up his client, and he's angry about it, and he wants the jury to know, and he doesn't care if the judge admonishes him. Okay, then he starts to ask for, a summary. How did you get all this stuff? And he's like, well, I know it was a Boston cop. I know it was a vehicle. I know they were traveling in reverse. He doesn't know who told him. Multiple people were saying it. He basically gets confirmation. The scene told him. Somebody said this. June said, I was told. Jackson was like, who told you? The crime scene told me. What else did the crime scene tell you? About something I don't know. I didn't put the evidence there. You didn't. Yeah, that's the part where, we just heard. But yeah, he's saying like the scene told him where this stuff was, meaning like where stuff was at the scene. It's like, it's not a great answer. It's not a great answer. Gosh, there's ones that I want to hit here. Jilly, Peter, that's a great point. Doesn't the court have to deem an expert to be able to testify as one? There's no way he got that designation. Usually, yes, but usually only if the defense objects. And I have seen cases. I have never done it myself. Actually, there's a case that hasn't gone to trial yet that I'm doing this on, where the expert is so bad, but not even so bad in my case. The expert is not the right expert for what we need. And when you compare him to our expert, he doesn't have the right specialty. He doesn't do the same surgeries. He doesn't teach on the same stuff. And it's just not a good resume. I'm not objecting to that guy because I want to do that comparison. So I have seen people, it's not quite like this. He's not this bad. I would probably object to this guy's testimony and get it thrown out altogether if I could. But maybe the defense was like, we don't want them to go get a better accident reconstructionist. We just want to have to make them deal with this guy. And that's possible. Somebody else said something else about this guy. Oh, here we go. Peggy. The judge did not allow him to give a definitive opinion as a result of voir dire last week. So I think I disagree with you. I think he gave a definitive opinion on how he thinks the accident happened in the car at John O'Keefe. What I think the objection to was last week in the voir dire was about was could he give the opinion on to how the damage got done to the accident in John O'Keefe's driveway based on the Ring doorbell camera, and he never finished that testimony. So we didn't hear the judge's ruling, but I think she did not allow that in, and that's the right call, and that's something that's beneficial for Karen Reed. So it's important to highlight that for, how everybody feels about the judge and stuff, but she kept that stuff out. This guy was not allowed to testify to that as it was a late disclosed or undisclosed expert opinion, which is absolutely the right call by the judge. Okay. Then Jackson, though, speaking of that, perfect timing for this question, Peggy, Jackson starts asking about the scratches on the car. And I was like, he's kind of opening the door to that Ring doorbell camera, but he kind of slows it down. And it might have been from this. It might have been from that. And then Jackson gets into the glass on the bumper, which a lot of you pointed out as well, that he said it was from the cup. Jackson's like, it's not from the cup. And his answer couldn't have been worse.
January 21?
Any and all of the scratches? So that's I'm saying you're being pretty broad. Any and all scratches on the car.
Answer that question.
That predate. Objection. I don't know every single scratch on that car. I mean,
Overruled. So can you answer that question?
no.
You testified that you noted glass on the rear bumper of the SUV, correct?
Yes.
And you said something about that glass coming from the cup.
Correct.
You also said that you did not see anything on that SUV that could be the source of those glass pieces on the bumper, right?
Yes.
When you did your reconstruction and your analysis, were you informed that none of the glass pieces, not one of them, would be matched to the cup?
I don't know anything about I don't know that.
So if you knew that the glass pieces on the bumper do not match the cup, that change your opinion
Objection.
about that glass?
Can you answer that question?
I cannot.
You can't answer the question.
It's
How
what
can you not answer whether it changed your opinion or not? Either it does change your opinion or it doesn't. He is just trying to bail. He cannot wait for Cross to be over. I don't blame him.
was told to me as evidence
Got it. I will.
by the crime scene.
It was told to him as evidence by the crime scene. It's like, that's not a good answer, but it gets worse.
Who told you?
As crime scene, I was there. It says it's glass in the cup. When I did my initial inspection, that's what it was on from.
That's not what you just said. You said that's what was told to me.
Yeah, by crime. By crime scene. While I was at my inspection,
Wait, what?
it was told to me by the crime scene when I was at my inspection, at the initial inspection.
So what you meant by that's what was told to me is the crime scene talked to you.
Yes.
Crime scene say anything else?
I don't know what else you want me to say.
Did Trooper Proctor tell you that those pieces of glass on the bumper are somehow associated with the cup?
No.
So the crime scene told you.
Correct.
But if you knew that
At this point, he's like, I don't care how ridiculous it sounds. I've already said it. I got to stick with it. Stephanie, that's usually the case. You guys usually have your finger on the pulse.
crime scene was incorrect, and in fact, those glass pieces don't match the cup, that change your opinion?
Objection.
Sustained.
Would it change your opinion in any way if you knew that the glass pieces do not match the cup?
Objection.
I'll allow that. Can you answer that question?
No.
I'm sorry. No.
I don't. It's glass from a cup. It's glass. It's not. It doesn't belong to the vehicle.
Right.
It's glass.
But if I told you it didn't match that cup,
What?
would your opinion?
Objection.
Does that change your opinion?
Are we talking which cup? We never established.
Not where you want to go, bro. You don't want to say which cup. You don't want to say which cup. We're starting to get into the territory where it's like, are you trying to treat the jury like they're stupid? Because everybody, all 19,000 of us here, and every person in that courtroom, including the jury, knows exactly what cup everybody's talking about. So for you to now go down this path of what cup, it was just a cup. I wasn't saying it was that cup. That's not being genuine.
Which cup we're talking about?
How many cups have we been talking about, Trooper?
You said that cup. When from the scene? Okay.
That cup. I'm talking
I just want to make sure that we're on a clear path here. I'm clear what we're talking about.
absolutely.
Okay. All I said, it's
found next to John O'Keefe's body in the snow at 34 Fairview on January 29, 2022. You got the cup in mind?
yes.
Okay. That's the cup. When I say cup, that's the cup.
Okay.
Would it change your opinion if I told you that the glass pieces on the bumper don't match that cup?
What's my opinion on it? All I said was glass from a cup. That's the only opinion I had. It's glass from a cup that was on a bumper.
Are you saying a cup?
A cup. A cup. It's not glass from the.
The judge is like, wait a second. You're just saying it was a cup at this point? Like, why is that helpful? How does that help us? How did it get there? What other, now that you're saying a cup, okay, if we know it wasn't John O'Keefe's cup, what cup was it? What did the crime scene tell you about what other cup this possibly could have been? Because none of this makes sense.
The car. That was my opinion on it. I didn't never said it matched to the scene.
You did.
I never said that in my thing. I said it's glass from a cup.
In this thing.
Okay. It's safe to say you didn't do it.
Jackson's like, "Oh, okay, I'm not really sure where to go." He talks about how John O'Keefe was 7 feet from the roadway. Lieutenant Gallagher, I think, was the one that measured that. He said, what if somebody else said 15 to 20 feet? How would that change it? Obviously, if all of your measurements are wrong, then everything's going to be wrong in your report. He said Gallagher was basically like pointing around to things like, yeah, this is where the pieces were. That's where the body was. This is where the glass was. And he was just like using that to recreate the scene and create that chart we saw. Not good, not specific, not scientific. Then they go into key cycles and they go different between key cycles and ignition start cycles or whatever. And Jackson was really laying it on thick to confirm that's how he used things to trigger events. Then he starts using the odometer and Jackson's like, you've been watching YouTube? Like, who told you to use the odometer? Because when you testify for Lally, you use key cycles. And Jackson was trying to set it up to say the last time Karen Reed turned on the car or drove it was not that night. So if we work backwards, we've got to include when it was driven up on a tow truck, driven into the Sally port, driven here, driven there. And when this 24 mile an hour in reverse happened, Trooper Proctor was in possession of the car. Now, I think it's a reasonable argument, not the best in my opinion. It definitely didn't prove Trooper Proctor had it. But what it evidenced to me is when I kind of rolled my eyes at it when Jackson made that argument, I was like, so I guess I don't think this stuff is that important. I don't really understand this key cycle stuff. I get that she hit reverse at some point, 24 miles an hour, 62 feet. Okay. That could have been when she hit. And that's kind of what I got from it, which is probably what the Commonwealth wanted. But maybe some of you guys thought that was a better argument potentially. All right. Then here's where Jackson gets on him for being imprecise and using words like stuff in your report and telling the grand jury you were going to go do stuff and you never did it.
Yes.
You were asked, does that remind you that you were asked by a grand jury if you could calculate how far a body would move having been struck by a vehicle?
Yes.
And you indicated, well, yeah, there's certain calculations you can do with that, but figure out if you save the car back up, hit somebody, and then they go a certain amount of distance, and it's based on miles per hour, the speed of the vehicle, striking vehicle, and stuff. Remember saying that?
Yes.
What did you mean by stuff?
I don't know.
You said that the
Yeah,
calculations.
bro, none of us know. That's why you don't use words like stuff in your report. I can use it when we talk. We can use it on the phone. We can use it when you talk to an expert. You can use it on YouTube. You can use it in text. You can use it in emails. But when you're an expert writing a report, you can't use words like stuff, velocity, whatever. Use some big experty words like somebody just said. Somebody said he's the least expert witness. I agree.
Based on miles per hour and stuff. Did you ever do any stuff to test that? The grand jury's question.
No, we cannot calculate anything from this collision.
Say that one more time.
We cannot calculate anything from this collision.
Who's we?
I'm sorry, me, the role me.
Well, you know John O'Keefe's weight, right?
What's that?
You know John O'Keefe's weight, 217 pounds, right?
Yes.
Did you know that?
I don't know his weight now.
You know the weight of the vehicle?
Yes.
What's the weight of the vehicle?
He didn't know John O'Keefe's weight. I missed that the first time through too. It's like, how do you not know his weight? I mean, I know the crime scene can't tell you that, but you got to know his weight.
gross weight.
What's the gross weight?
Yeah.
I think it's approximately 7,300 pounds.
Were you able to calculate the mass of the vehicle?
I did not calculate the mass of the vehicle.
Well, you told the grand jury that you were planning on doing that kind of stuff to calculate how far a person would travel being struck at that speed with a car of that weight. You didn't do those calculations?
No, because the calculations would vastly underestimate the speed of the vehicle.
You testified, again, my report isn't done yet. I'm going to look into it. I'm looking into all that stuff, end quote, correct?
Yes.
There's that word again. It's been more than 2 years since that statement at the grand jury. Is your report finished?
Yes, it is.
Did you engage in any of those calculations?
I looked into it. This type of collision I would not be able to use the formulas for this type of collision.
Well, let's talk about those formulas. How would you calculate how far a body at rest would travel after being struck by an object in motion? How would you calculate that?
In pedestrian collisions, I use a Searle formula, Searle-Fro formula.
What formula?
Searle.
What's that mean?
It's a type of formula that we use for calculation of post-impact
So
speeds for pedestrians.
that includes certain principles of physics to calculate that, right?
What do you mean?
I'm sorry?
What do you mean by certain forms of physics?
There would be physics calculations that would be required to figure out how far a body at rest would move having been struck by an object in motion.
Right.
That's a basic principle.
Yeah, I guess you could say though.
All right. Can you describe for the jurors exactly what calculations you would need to employ to determine how far a body at rest would travel having been struck by an object in motion?
So in this scenario, in this collision, it's more of a side swipe. So he did not sustain, he did not get enough speed of the vehicle post impact with the vehicle to be able calculations. His center of mass was offset from the vehicle, so we would vastly underestimate his speed. So that's why I did not do a formula. If he was more in line with behind the vehicle, he would have been projected forward, and using that projection forward, he would have been able to get more closer to the actual speed of the vehicle there in that post impact travels.
So he keeps saying that as if you can't do a calculation and say, but this is low. It would have usually been more because of that, which I've seen people do. It's not the best, but it's better than nothing.
Well, that presumes a couple of things, Mr. Paul. That presumes that he was quote unquote satisfied, right?
Presumed?
Presumed by you. You didn't see how he was in, did you?
Based on the evidence, it appeared to be a side swipe.
That's your opinion.
That's just reading the evidence.
You're saying that the principles of physics as we know them today in modern mathematics is thwarted by a sideswipe?
Objection.
Is that what you're saying?
The calculations that are out there, you can get a speed, it will just underestimate the speed.
You would have to know what the initial momentum of the object is that's in motion, correct?
Of what object?
The truck, Mr. Paul.
I would have to know that speed.
Yeah, you'd have to know what the initial momentum is, not speed, momentum. There's a difference,
Okay.
right? Would you agree with that?
No.
You wouldn't have to calculate what the initial momentum is of the object in motion to determine the distance of the body at rest would move?
Well, now in that sense, are we talking about trying to find the speed of the vehicle? That's usually what we're trying to do.
Right, okay, well, let's put the speed of the vehicle aside. Let's talk about initial momentum. What's the formula for calculating initial momentum?
There's different types of momentum formulas.
Well, there's actually one type of momentum formula. It's to calculate momentum.
Objection.
Sustained.
To calculate momentum, there's a
So sustained. Ask it differently.
Isn't it true, Mr. Paul, that there is a singular calculation for determining initial momentum? That is P equals M times phi, where P is the momentum you're solving for that. M is mass, you multiply that by velocity. Is that right? Pretty simple.
You wouldn't use that in a pedestrian collision.
Oh, because the pedestrian's somehow magically out of the realm of physics?
Objection.
Sustained.
Is a pedestrian out of the realm of physics and calculations?
No, it's the weight differential between the pedestrian and the vehicle.
So if the vehicle is too heavy and the body is too light, you can't calculate the initial momentum of the vehicle?
Yes.
Got it. Would you
I've never heard anybody say that. I'll just say I've had it done. And pedestrian's much smaller than John O'Keefe. Matthew said, do you think Trooper Paul will be moved from his current job to a road trooper now that MSP knows he's terrible at his job? I hope he gets more education and more training and more classes. That's what I hope happens. Peter, have you ever had an expert that is this bad? I felt bad for him until he protected Proctor at all. Lily and Chris say hi from Australia. I've never had one of mine that's been quite this bad. I have had one that was really bad in one trial one time. I wasn't directing him. Pete was, and it wasn't Pete's fault. The expert just like vomited all over himself. And we were like, what just happened? And he apologized afterwards. We still didn't lose, but it was rough. I'm going to jump ahead a little. Actually, I want this last line.
or not?
It's in my math class. We don't use momentum for a vehicle to vehicle.
Math class?
The fracture construction classes I have taken.
Got it. Would you need to apply the theory of conservation of momentum in calculating these data?
Do I need to calculate the conservation of momentum?
Conservation of momentum.
Yes.
You know what that is? There's an equation for that as well, right?
Yes.
You know what that is?
Not on the top of my head, but yes.
It's tough. It's tough out in these streets, man. It really is. Azam, when talking about Jackson being admonished, said, you say the jury usually trusts the judge. They do. Does it make AJ look bad in the jury when the judge reprimands him for his comments multiple times? Yes, it does. But I think part of the defense's strategy is to show the jury we're outraged. This is so bad what they're doing to Karen Reed. Everybody's in on it. All these cops are trying to pin it on her and protect the Alberts and protect the cops. And we're mad about it. And we're here to fight about it. And the judge may tell us to calm down, but we're not going to calm down because we're angry. Sometimes that's like the theme of a trial that lawyers really get into. OB Nurse, if the Commonwealth doesn't call the ME, is a DVSJ more likely? No, I really don't think that's going to happen at this point. I really don't. I mean, more likely, sure, but I don't think that's going to happen. Katrina, if the wheels are spinning on ice, would the odometer still be recording and speed sensor still be recording? I don't know the answer to that. I don't know the answer. Yeah, it could have. So I'm super confused, Peter. Is the Commonwealth saying the SUV hit John in the back? I believe so, but he's about to explain this a couple times, so we're going to get to that. How did it connect with John? We're getting there right now, actually, so let's get to it.
Been formally trained and hold no degrees in biomechanics?
I do not have a degree in biomechanics.
In fact, basically what you did in this case was calculated ignition cycles. And you got those wrong, right?
Objection.
Sustained. Come on, Mr. Jackson. Ask the appropriate part of the question, you'll get it.
Let me ask you this. Based on your reconstruction, nearly 2-year investigation, exactly how was that taillight shattered?
Here we go.
Explain to us.
How does the taillight, so the taillight in this case was shattered when it was struck John O'Keefe's arm.
Exactly what part of his arm?
Based on what I saw for his injuries, was from the upper part of his arm down.
Was his arm out? It just struck the arm?
Like, could he be less precise? It shattered when it struck his arm from the upper part down. It's like, so that's the whole arm then.
Arm on a hinge? Is it in front of him? You did the reconstruction? It shows exactly how his body was positioned when he was struck by that.
So it looks like his arm is more kind of like this. If I can try to get that.
You're indicating out by his side, correct?
Yes.
All right. And the taillight would have struck his arm, right?
Yes.
Not his torso.
Yes.
Okay. So the full mass, full weight of that truck hit him basically at the elbow. Is that right?
No. I said it's the upper part of the arm down. Yeah.
Elbow and biceps.
I didn't see anything that shows an indication that this lower torso was struck, but
Okay. So
it's not saying it could not have been possible.
Which is crazy. I mean, that's evidence right there. He didn't see any indication that the lower torso was struck. So the full force of Karen Reed's Lexus struck John O'Keefe in the arm in such a way that he flew, tumbled, pirouette, whatever, 30 feet to his death, and had blunt force trauma to his head. Maybe the blood pooled in the front of his face, maybe his eyes, maybe the front of his face hit something, but no damage to his torso visible that you would expect when somebody would get hit by a Lexus, by a car. And I would agree with him. It's usually not just internal injuries. Usually you can see stuff externally.
But I didn't see anything.
So his torso was spared from being hit, but the arm took the brunt, the full force of the vehicle, correct?
Like arm and shoulder, yes.
Okay. And you said he then did a spin, like a sort of pirouette?
He got spun around possibly the way he struck, it looked like he could have turned around counterclockwise.
Okay. So if he turns around counterclockwise, is he turning around in the air counterclockwise?
Yes, initially.
So he gets hit on the upper biceps, shoulder area, and down to the forearm, right?
Yes.
By an unbroken taillight, right?
Yes.
In other words, it's nice and smooth. Nothing, no shards of plastic or anything broken at the time that made contact with his arm, right?
Correct.
Okay. So how does his arm get up?
Because when his arm struck the taillight didn't crack. And as the car is driving past him, the taillight could scratch it.
Got it. So he gets hit by the car, not his torso, just the arm.
So I actually think Jackson could be wrong about this. I think if you were going to shatter something on your arm, you could get scratched. But the witness gave him an even better answer, because he said it cracked and then stayed with his arm to scratch him. So his arm stayed on the car long enough to crack the taillight and get scratched as it was throwing him forward. It's not plausible to me. It's not even reasonable, let alone beyond a reasonable doubt.
It cracks. And as it passes by, his arm stays with it long enough to get striations, those scratches that you see, those lacerations, I'm sorry, those abrasions that you see, right?
In a sense, yes.
And at the same time,
In
he
a
does
sense,
pirouette and flies 30 feet to his final point of rest.
I don't know if he did a pirouette.
Well, I'm using the word pirouette. He spun around.
He started rotating counterclockwise. I don't know how far he ran counterclockwise, but he started rotating. According to that, would push him to rotate counterclockwise. Whether he went counterclockwise all the way to his back toward the ground, it seems like a most likely possibility.
Did you account for the fact that his arm is on a hinge?
Is what? Say again?
Did you account for the fact in this scenario that you just told the jurors that his arm is on a hinge?
On a
his
hinge.
shoulder?
Okay.
Right? So arm got hit. Did his arm just swing?
I said arm and shoulder area, so his arm could have been considered part of it.
Even if his shoulder got the upper pointing to his upper biceps.
Mhm.
Right? There's no injuries on his shoulder, not a single one, not even a bruise, right?
Like I said, it looked like to me it was from up here. I don't know how far I can up back here, but it was up here.
Well,
So
you're the one that talked about his injuries on his arm.
yes.
That's limited to about mid biceps, about mid forearm, right?
Okay.
Right?
Yes.
No injuries on the shoulder, no injuries on the torso, no injuries on the ribs, no injuries on the back, correct? Is that right?
Yes.
So your theory is you got hit on the arm, took the brunt of the force from the taillight on the arm, stayed with the vehicle long enough for the taillight to explode, basically to shatter. Then these striations get on his arm, abrasions. Does a pirouette, spin counterclockwise, and flies 30 feet in the air to his point of rest.
Yeah, have to probably go faster than that though.
No, sorry, that can't be what happened. So here's what I have to say for all those people that are saying Karen Reed did it. None of this matters. People are going to find a way to explain stuff away. I don't really care. And again, people on both sides, I'm hearing for people on both sides, I don't care about the cover up. I don't care about the Alberts. I don't care about the McCabe's. I don't care about Proctor at this point. I don't care about the conflict of interest. I don't care about any of that. You as the Commonwealth have to prove to me that her car hit and killed John O'Keefe on purpose. That explanation makes absolutely no sense. There's no data behind it. There's no proof behind it. There's no evidence behind it. He can't tell us where he got any of this information, and he is completely guessing. So if this is all they have at this point, ain't no way that that's enough to prove that. Imagine if somebody was like, you got, I don't know if YouTube wouldn't like this, but if there was a projectile that came out of a weapon that I was holding in my hand, and they explained it that I had the weapon in this building and I shot it and somebody died in New York City, and they try to explain to you how that makes sense and that's what happened, it's not possible. It's not how it works. You got to give me more than that. You got to tell me what's that story or what's that movie with Angelina Jolie where, they could shoot around the buildings or whatever. Like, you got to explain to me how that works, because this is not it. This is not it. People are not going to like the fact that I don't care about I'm not saying I don't care about the cover up. That's horrible. If they're covering it up, it's horrible. If they're trying to push it on somebody who didn't do it, all of that is horrible. But it's just your everyday normal criminal defense case without all the conspiracy theories. This is not proof beyond a reasonable doubt. This can't be it. This can't be it. Maybe they have another accident reconstructionist. I don't know, but this can't be it. And he does it. He's going to explain it 2 more times before we're finished. So you tell me if it gets better. 2 more times he's going to explain it with his friendly lawyer.
That's what said he hit his head on the curb.
I said that's one of the possibilities of when you look at the roadway as he gets spun around kind of clockwise. It's a possibility that the curb is the.
So in his own explanation, he left out the hit on a curb part, which again, blunt force trauma, all that, that would help. That would kind of make sense. He left that out this time. Now he's saying that could have happened. So his explanation, he just said, now he's saying that might not even be what happened.
There, any blunt force object on the ground the ground is pretty blunt.
Well, except in your scenario that you told us, he flew through the air onto the light dusting of snow, grass, and dirt.
I didn't say through the air.
Say that again?
I didn't say he got thrown through the air.
Okay, I'll use your word. Got projected.
Projected doesn't mean it's not incorporating just throw. Project just means you get pushed forward. There's 2 parts of that. There's the air, then there's the ground. Like I said earlier, the tumbling, the rolling, whatever. That part of the crash would happen. Projecting is just what we call what happens to a pedestrian post-impact with a crash.
Okay, so a couple questions.
Emily, thank you for your expertise on this. I do think this is important. And the Commonwealth seemed offended with the word pirouette as well. Paulina, I agree. How did the arm not break? How is that enough? Like, if you just hit my arm, maybe his arm like flies off or flies out of the socket before it's going to knock a 220-pound body 30 feet. If you just get hit in the arm. Now, it could knock you maybe over and you fall face first onto the curb and you hit your head, and blunt force trauma to the head can happen in crazy ways and take someone's life. But nobody's saying that's what happened. What he's saying happened to me. I'm just saying one guy's brain, okay? One guy's brain. I'm not the smartest guy in the world, okay? Nobody's ever accused me of that. I can't get past that. Now, maybe the jurors feel a different way. So I'm not saying the jury has to do something, because the jury's going to listen to the evidence. They're going to weigh it. And it's up to them. It's not up to me. But this is just how I see it at this point.
If his arm, elbow, grunt, that entire impact, how do you account for the fact that he didn't suffer a broken bone?
I don't know.
How do you account for the fact that he didn't have a fracture?
Objection.
Sustained.
How do you account for the fact that he didn't even have a bruise on the arm?
Objection.
That's sustained.
Fair approach.
Yes.
So when he comes back from the sidebar, he basically says, Proctor told you to do all this. I didn't think it was that effective of an end of cross. Some of you guys did. Obviously, you asked questions about it, so maybe it stuck with you a little bit more than it did for me. Then we get to redirect. He has him reiterate basically that the triggers are consistent with a pedestrian strike, which he said multiple times. Talked about the 3-point turn, how Karen Reed even said she made a 3-point turn. The area of impact is broader than the point of impact, which you already know. He runs through some more of the points to repeat. Oh, then Lally asks when a picture is taken. This guy clearly doesn't know, but Lally can't help himself. So once again, he tries to throw in a little leading question to get the answer. And it's just, you shouldn't do stuff like this. We hit Jackson for doing things that are inappropriate. Lally too. It's like they're both pushing the lines.
And this is a fire hydrant.
And as far as the photographs and the photographs shown to you by Mr. Jackson on cross-examination, do you know when those photographs were taken?
I do not know specifically at what time those were taken.
You don't know if those photographs were taken on February 3rd, 2022?
Objection.
Is the objection sustained?
I don't know when those were taken. You don't know if it's February 3rd? It's like, it's not how you get evidence in, man. It's not how you get evidence in.
Now, explain to the jury as far as what you were describing as Mr. O'Keefe's post-impact movement, starting sort of with the point of it.
So here it is again. Mr. O'Keefe's post-impact movements.
Back between himself and the SUV to the point where he comes to final rest on the wall.
Yes. So he was struck along the right side in the area of his arm, and then he was post impact with the Lexus. He rotated counterclockwise and eventually hit the ground and came to final rest.
And the ground, based on your understanding of the weather conditions, was frozen.
So that was it.
Post impact with the Lexus. He was struck along the right side in the area of his arm, and then he was post impact with the Lexus. He rotated counterclockwise and eventually hit the ground and came to final rest.
So we've added some things. The left side of his body and arm. Sorry, right side of his body and arm. Did he say left or right? Let's listen one more time. Sorry.
He was struck along the right side in the area of his arm, and then he was post impact with the Lexus. He rotated counterclockwise and eventually hit the ground and came to final rest.
And the ground, based on your understanding of the weather conditions, was frozen at the time. Is that correct?
Objection.
Sustained. Watch the form, Mr. Lally.
Yes, sir.
So now, and he hit the ground and then eventually came to final rest is how he explained it there.
So as far as anything in your
A little bit more vague, a little bit more plausible, hardly proven that that's actually what happened.
testimony about Mr. O'Keefe's actions, does that involve a pirouette?
No.
Or is there a rotation, is that correct?
Correct.
And as far as 30 feet in the air, do you have any opinion as to whether or not he flew 30 feet in the air?
I don't have any evidence that he would have flown 30 feet in the air.
And so as far as from your training experience when it comes to pedestrian collisions, are you able to determine or calculate how much distance someone is in the air and how much distance someone sort of rolls or tumbles to their final resting position?
Say it again.
From your training experience,
Yes.
based on this collision, are you able to determine how far Mr. O'Keefe was traveling in the air versus how far he traveled tumbling or rolling after he hit the ground?
I do not have a calculation for this specific style of pedestrian crash due to the side swipe. So if I did, I could use the formula. It would just vastly underestimate the speed of the vehicle.
So he asks him a question. Can you actually prove how far he flew versus tumbled? And he says, no. So we don't know if he flew. We don't know if he tumbled. We don't know what happened or exactly how his body moved after, outside of it just hit him in the arm. B&B, why did Lally keep objecting to the injury questions? Maybe he saw how it was going like we did. I don't know of another reason. Dave, are we in directed verdict territory? I don't think so. I would be really shocked. I feel like AJ consulted with his experts on the questions. Absolutely. Absolutely. He made him look really bad. I thought he was going to plead the fifth as a witness. No, I mean, I didn't necessarily think that, but most likely, possibly, maybe reasonable doubt. It's tough. It's tough. Is this guy the scapegoat of garbage in, garbage out? I mean, he didn't even tell us how he got the garbage in. I don't even know what the garbage is he used. Okay. Let's see what else. He gave a bunch of different possibilities as to what happened to the glass on redirect. And then basically it sounded like they were saying the key cycles aren't that important, but on direct, it seemed like they were really important. He says the defense's illustration of how the key cycles and how Proctor had the car at the time, it was wrong. It didn't work. That's fine. And then here we go. The final kind of explanation of what happened. What happened to John O'Keefe's body?
Describe to the jury how you believe the vehicle interacted with Mr. O'Keefe and why.
Objection.
Which he's asked it 5 times. Objection, asked, and answer sustained. And then he asks it a different way, and she lets him answer, which is the same thing, but whatever. We get to hear it one more time to give the Commonwealth the benefit of every doubt.
Sustained. Asked and answered.
With reference to what you described as far as the interaction between Mr. O'Keefe and the vehicle, why is that your opinion?
Objection.
I'll allow that.
Based on the evidence from the vehicle, based on the injuries to John O'Keefe, the tail light appears to be broken and the sharp plastic pieces that could have ripped his arm, and also the dent with the scratches above it is consistent with a hand holding a glass and the glass on top, smashing on the vehicle, and the hand smashing the vehicle. You can see there's a line between scratches and a dent there.
So that's where he said, now we have the hand holding the glass. So it wasn't attached to him. It wasn't under his shirt. The hand is holding the glass, and it's hit like this, and he holds on to that glass because it ends up right next to him. And his cell phone, if it was in his pocket, it flew out of his pocket, but then ended up underneath him. If he was holding his cell phone in his hand, which we don't know, but that also stayed in his hand while he tumbled or flew or whatever for 30 feet. And I think he thinks the glass is in his hand because the shards of glass that are on the SUV that don't match that glass, the only one that we care about. All right. So that was basically it. This expert was a tough watch. It was a tough watch. I'm going to run through some questions, see if there's anything more on him. Because some people are asking questions about stuff we're going to talk about in the future. Seems Paul was the only expert Commonwealth could find that agree with their scenario. Do they have to disclose all experts they solicited for an opinion? Not in most jurisdictions. You don't have to talk about every expert that you talk about, especially if you're not going to call them as a witness. And if they just kind of give you an opinion over the phone versus in writing, it's different in different jurisdictions. A lot of people asking if I'm going to talk about a certain part, which I will. If Karen Reed or when Karen Reed wins, can they try her again, or is it double jeopardy? It would be double jeopardy. Maybe I'm soft, but I feel bad for this guy because maybe he was forced into this. I feel bad for him as well a little bit, but I also kind of made your own bed. I'm a little behind starting the live, but I was so excited to hear your take on Proctor Paul, Trooper Paul. This guy's an expert, barely. James, man, if a lawyer knew more about my job than myself, I'd be on the hunt for a new career. Good idea, James. Good idea. The Fast and the Curious. So he already testified at the grand jury with the same opinions and used the same verbiage, and the state still thought he would be the best expert to testify about the crash reconstruction. Well, he was supposed to do some other stuff after testifying for the grand jury. He just didn't. Can AJ have asked something like, is there any evidence that could change your opinion if these fundamental errors in your info don't? Yes, he could have asked something like that. Jilly, full vehicle weight hit his elbow, but didn't even break his elbow. Ashley, is it possible that Lally didn't choose this expert witness and he was instead told to use him? How much ownership does Lally have over the Commonwealth's case? Usually, if you're going to try a case like this, you've got some say. If you're going to have some say in your experts, but sometimes a case gets dropped on your desk, the investigation's mostly done, and you got to work with what you got. I think he's trying to say that John landed in the vicinity Buchanan described right after doing the Macarena on the roof of Higgins' Jeep. Okay. Can you please make sense of the Cellebrite expert? How is the search now at 10:33 a.m.? I picked up on that as well. Conflicts with their other experts. Go Celtics. Let's get to the Cellebrite guy now. He says he was basically brought in because people had questions about the 227 timestamp. It didn't make sense. He's been asked similar questions. He created a program that I think he said like 600 people use. And let's look at some of the evidence that he sees in this case as important.
And
he's got an accent. I think accents are great for experts as long as the jury can still understand what they're saying. Usually they're like, oh, he sounds smart.
what is your opinion as to when the search was conducted?
There's plenty of other evidence on that extraction that shows what activity was occurring at 2:27 and 40 seconds. And there's plenty of evidence later on in the day that shows that that particular search was conducted at 6:23, I believe 51 seconds, and then a similar search at 6:24 and 18 seconds, I believe.
So that's the gist of his testimony in the beginning. There's plenty of evidence the search wasn't made till 6:23. He confirms it was McCabe's phone, confirms some records, puts up a chart that actually says deleted, but then he explains a little bit about why that's not actually what it means.
Aside from physical analyzer?
Yes.
Okay, so I have my own tool called Artex, which I've been working on for around 5 years, since been examining myself and struggling to pass any particular application I needed. So I started to write my own tools, and that's the one that is one that I still maintain on the side in my own time, partly for my own knowledge, but partly because I think it still introduces some fantastic features which aren't available in any other tool for research purposes. So yeah, I continue to write this tool to this day.
Could you just say the
He came up with a tool on his own. Pretty cool, in my opinion.
Artex, ARTEX.
Now, with regard to the situation depicted in the exhibit up on the screen, what are some of the reasons why this may occur, or why this may read as it does?
Sorry, is it deleted?
Yes.
So, the record itself has been deleted. As I said, the reason why it's deleted, through my testing, I've only found 2 ways that that kind of record can be deleted by the user, and I don't believe either of those ways was actually utilized on this device.
And what are those 2 ways?
The user has the option to selectively delete history items, so you can delete either one at a time, or the entire day's content, or the last 2 days' content, or you can delete all content altogether. Now, if all content had been deleted, we wouldn't have found any information on this phone at all related to web history, so I was able to discount that one quite quickly.
And I guess alluding to what you just said, why is it that you don't believe that either of those 2 methods of user deletion occurred in this context? Objection may be reported, please.
I'm sorry?
I said objection may be reported.
Okay.
And basically he's like, so why don't you think she did one of those? He explains how it works. It's a little bit confusing. We're going to get to kind of the totality of his opinion here later. And then here's where it got weird. He said the house long to die in the cold actually happened at 10 something. I just want to listen to it together because as a group of 22,000 of us, maybe we can figure it out. And yes, hit that like button if you guys have not already. And Azam, I think, made a comment earlier that I wanted to put up. Yeah, Azam, hit the like button. We're at 380,000 subscribers. Like 40% of the people that watch these Karen Reed videos are not subscribed. If all of you guys just subscribed, we'd hit 400 before the end of this trial, which would be crazy and would be awesome. So hit that subscribe button as well. All right, let's listen to this, to try to figure out when this search. We've heard 2:27, we've heard 6:23, and now we're hearing 10:18, it sounds like to me.
3 a.m., so around the time of the Google search, if you were to believe the browser state.
And with respect to the items highlighted in blue, what are those?
The ones in blue are the actual Knowledge C records that show when the How Long to Die in the Cold and the How Long to Die in the Kikti web pages were actually visible on screen.
And so from this, what, if anything, were you able to ascertain as to the searches or the time associated with searches from your analysis?
At 2:27:40, the only websites that were visible on screen were related to Ozone Basketball and Hockenmock Sports, and that the How Long to Die in the Kikti first appeared on screen at 6:23:56, and How Long to Die in Cold first appeared on the screen at 10:33 a.m.
So what I think he means, okay, and I am not a cell phone expert at all, okay, what I think he means is it was typed in at 6:23 or 24 or whatever, but she didn't actually search it. So when she re-brought up her phone later at 10 whatever, then it searched and the actual results came up. That's what I think he means, but I'm not positive, and we're going to get a little bit more on it later, but that's what I think he's saying, okay?
2 searches from your review of this extraction in this device never appeared on the screen prior to 6:23 in the morning, correct?
Correct.
Now, from all this, sir, what, if anything, were you able to conclude with regard to these searches?
So essentially, ignoring the browser state timestamp is important because that is not a reliable timestamp to show when that URL was visited. We have mobiles.
So he just straight up came out with it. Ignore the timestamp. It's important to ignore the timestamp. And he's going to explain why. And I think he's pretty convincing, honestly.
Safari.plist record searches that show 6:23 and 6:24. And we show the same searches with very similar timestamps within half a second. as showing up on screen in knowledge C for the how long to die in the Kikti. And the how long to die in the cold was actually several hours later, which took a little bit more explaining, looking at knowledge C and when the applications were opened up.
Now, with respect to your view of the extraction of the device around these times, were you able to ascertain as to what time this particular device connected to Wi-Fi sometime after 2 a.m.?
I actually didn't look at any Wi-Fi connection information.
Why would Lally ask him that? I don't get that. Okay. He said all these records are deleted without the user doing anything. But then, for the first time, we're going to listen to the last 10 minutes of his direct, just kind of get his full opinion. But he said that he couldn't replicate or simulate how this stuff was deleted, which to me is like, that's sketchy. You're this expert. You should be able to recreate all this stuff, just like he does a demonstration, which I think is pretty effective. I know people are saying he's using his own tool. He could do whatever he wants. My guess would be the defense would object if his tool was not legit. And if the defense's experts tried to use his tool and it was not legit, they would object and it would not come in. It would be junk science. That would be my guess. I don't know that happened, but I'm going to assume if it came in a trial, it's reliable, at least enough for the judge to think it passes muster to be an expert testimony to do this demonstration. And with that in mind, I thought it was pretty effective myself. We're going to listen to it as we get to the end of his direct. But I did think, based on all that, I thought it was very strange that this guy could not replicate how this stuff was deleted off Jen McCabe's phone, but he is positive she didn't. He's positive. We're at 381. Come on, people, hit that subscribe button. Hit it. Hit it.
Now, with respect to sort of the totality of your analysis, Mr. Whitman, what, if any, conclusions did you come to as to the timing of the two searches in question with relation to what you observed in your analysis and testing of this device?
Yes. So in conclusion, I determined that the tab that was used was focused at 227.40. So the tab was opened at that time, at which point it was being used to show Ozone Basketball and Hockomock Sports websites. The 6:23 timestamp is when the search was first conducted. Never loaded the page, otherwise there'd be a record in the history database. And while that page was still loading, a secondary search was conducted for How Long to Die in the Cold. Again, that page never loaded either, although these both did show up in the Knowledge C database to show that the browser was trying to display these pages. Safari was closed prior to the How Long to Die in the Cold record being shown on screen at all. But when it was reopened at 10:33, in regards to whatever other Safari activity was to be conducted, it appeared on screen. So we have a 10:33 record where How Long to Die in the Cold was shown on screen, even though the page never successfully loaded.
So that makes sense to me. But why would it show up twice? Why would it show up at 227 as well? That doesn't really make sense to me, but I kind of believe this expert. At this point with the cell phone expert stuff, I'll wait to hear from the defense's person. But I'm thinking in my head right now, after I just heard from that accident reconstructionist, does this even matter? Does this even matter? And I know everybody's going to say, of course it matters. The defense says it's a cover up. If the defense is wrong, they should lose. That's not how it works. The defense can be wrong about every one of their theories. They can point to 10 different people and you can think it wasn't those 10 people. If the state does not prove it was your client, it's still not guilty.
And with respect to your analysis and your testing here, what, if any, opinion you have as to whether or not any of the data marked as deleted was actually user deleted or the user actually actively went through the process of deleting it?
Yeah. So again, we know that we know that nobody deleted the entire history. So that leaves the only option to be selectively deleting records. The fact that there are no missing records in HistoryDB shows that it's impossible that that record could have been deleted by the user. It would have just been orphaned in the database, and I believe would have deleted itself at some stage whenever a particular cleanup function ran. Although, as I said earlier, I haven't been able to replicate that. I was able to continue to read the various versions of the page that contained How Long to Die in the Cold browser state record, and found that it existed at the same time as another record that was created at least 2 days later. Therefore, I can determine that that particular record was not deleted until at the earliest 10 p.m. on the 31st of January. And it's not possible that the user could have created or caused that deletion to occur.
Now, over the course of your analysis and testing, a review of the extraction in this case, did you have occasion to review an affidavit of a Mr. Richard Green?
I did, yes.
And what, if any, opinions or conclusions do you have as to that affidavit?
I had issues with several of the statements being made as part of that affidavit.
So this is the issues he has with the defense experts' opinions.
Good.
And what issues were those?
Namely, it specified that Cellebrite report identified that the search was conducted at 227.40. And as I've explained, I believe the tab took focus at 227.40, not when the search occurred. The report mentioned that Cellebrite report...
He said, I believe, which is interesting verbiage.
identify it was deleted by the user. We don't do that. We'll tell you that a record is deleted, but we don't specify how the record was deleted. That's something for the examiner to determine.
So once the examiner determines it, can't the examiner say it was deleted by the user? I don't know.
I forget. Oh, and then there was a mention of the purpose of the browser database. The explanation given was correct for iOS 14 and below, but not for 15 and above, which is relevant in this case.
Now, you mentioned this issue as far as coming up, obviously, in this case and some other instances, phone calls or inquiries that you received from Austria and other places. What, if anything, have you or your company, Cellebrite, done with regard to rectifying this issue?
Well,
I'll allow it.
we recognize that this timestamp could be misleading. Regardless of how we label that timestamp, the very fact that a timestamp is there, we feel would be or potentially misrepresented.
100% I agree with you, dude. And this was my first thought when the other witness testified to it. So I'm like, so why do we have it? And people making comments like this. Cellebrite just confirms in open court that no search is accurate unless you close the browser tab, queue up the mistrial appeals on cell phone data. I definitely think it's an issue. I don't think it's going to maybe be that far reaching, but I mean, that to me is really interesting. And Sandra said, Peter, do you believe that Ian Whiffen, which is this guy, was an expert witness as a representative of Cellebrite or his own company? I think it was his own company, but the fact that he works at Cellebrite gives him experience and knowledge and expertise to add a lot of context to what they're all talking about here. And I found him to be pretty credible. Becky said, I like this witness, but I don't like spending so much time deflecting the defense instead of proving the CW case. I still don't understand it. It is hard to understand, but I'll say, this guy has a lack of education. Watch how Yannetti crosses him. He doesn't think that this guy is, I'm not going to say stupid. He doesn't think this guy's uneducated or doesn't know what he's talking about. Jackson absolutely felt the accident reconstructionist was. It's not all about schooling. It's not all about education. You can get it from experience. You can get it from learning yourself. You can get it from working on it, especially in computer stuff, in building your own apps and stuff like that. This guy knows what he's talking about. I found it to be overall pretty credible to me that, okay, maybe she did make this search at 6:27. That's kind of what I felt. Nikki said, Commonwealth spending a lot of time defending JM, LOL, hubbies and IT. We'll talk about that in a minute. Beetle said, do you believe the state has proved Jen McCabe's innocence? So no, what I'll say is the state has provided me with reasonable doubt that Jen McCabe made the search at 2:27. I don't know. I don't feel like I can say for certain or beyond a reasonable doubt that she made the search at 2:27. What does that answer in the case? I'm not so sure at this point, but I do think this guy did a good job in helping him with that.
So the decision was taken to remove the timestamp altogether from that information. So now we show the web page was visited, but we don't attribute a time to that purely because it could be wildly inaccurate.
So Cellebrite has changed the way they do business. And if this is legit, if the defense experts agree with this, then we kind of got to throw out the timestamps. If Cellebrite's literally throwing out the timestamps with this iOS software and at this time period and applicable to this, that's not good for the defense to prove it was Jen McCabe, right? Which is not really fully the defense's job.
Your Honor, this may be the appropriate time for the instruction.
Okay. All right. So jurors, we're about to see a demonstration by Mr. Whiffen.
This is a cool demonstration, cool instruction. And when I watched the demonstration and saw it in real time, I was like, okay, I guess it is possible.
It's simply a demonstration to help you to understand the evidence that you've heard. It's not evidence from this case, but it helps you understand the evidence in this case. You must decide this case based solely on a fair consideration of the evidence and nothing but the evidence. But this is a demonstration to help you understand that evidence.
Your Honor, I'd like to preserve, correct?
Yes.
Thank you. And so to that point, Mr. Whiffen, were you able to prepare a demonstration in regard to what you've been discussing through the course of your testimony?
I was, yes.
And that demonstration doesn't specifically reflect on the searches or the extraction report that you looked at in this case, correct?
Correct.
But as far as the overall issues that you've been discussing in your testimony, correct?
That's correct.
With court's permission, may the witness now illustrate that.
Yes.
Okay. So first of all, on the left there, you can see a screen of an iPhone, and that is a phone I have in front of me live. It's just demonstrating what I can see on the phone. This is my Artex tool. And the feature which I continuously use this tool for, which is not available really in any other vendor tools, is the ability to create a live connection between my computer and the phone. The live connection is what I've just started here, and what's going to happen is all of the files and folders that exist on the phone will be mapped to my computer so that I can navigate it, I can look around, and I can take a look at near enough live records on the device. Prior to the availability of this tool, I would have to test a theory on a phone, do an extraction, and then pass the extraction, which could take anywhere between 20 minutes and several hours. The reason that I'm using this tool today is because I can do those same tests within 10 or 20 seconds typically. So I just need to wait for this section to do. So it's already mapped out all the files and folders. It's now asking for a few important pieces of information, which it will then populate on the screen. So information such as the device, serial number, etc. What we're interested in, though, is the browser state record. So I can go to the browser state database and take a look at that and open that up. And you can see that at this moment in time, I have no records in the database at all. If I go back into the live view of the phone, you can see I have Safari open from last night. So it's been sat in the background overnight and not doing anything. But at 10 past 8 last night, I performed this search in a brand new window. So started Safari, opened up a new tab, immediately searched for new tab at 2010 on the 16th of June. If I now search for the time right now, 1442, what I can do is go back to my RTX tool and press this reload button. That's going to delete the database from my computer only and copy the most recent copy of the database and WAL file from my phone back to my computer, where it shows me I still have no records. That's expected behavior because at the moment I've not closed the tab. So if this again was iOS 14, there would be a record there to say what tab I had open, but iOS 15 doesn't work that way. If I now go back to my tabs and actually just close this window, I can go back into RTX and hit reload again. And we now see we have some records. I can look at this particular record and you'll see the title is 1442 Google search. You'll see the Google search record here. So I just need to change the time zone as well to Eastern time. So you see it's the most recent search which I conducted, the 1442 search. The last viewed time, though, still shows as 8:10 p.m. last night, because that's the time that the tab was focused, not the time that the search was conducted.
Thanks. Want to have a moment, John?
Yes.
I mean, that makes sense to me. That's plausible. I get how that happens. I think that is horribly stupid. I have no idea why it is that way. But Private's mom said, but how often does Cellebrite get questioned in the prosecution? Don't they rely on this for a lot of cases? Yeah. He was saying like maybe in the past, I think it was more accurate with 14, the iOS 14 versus 15. I don't really know. Mo said, does it feel like a free commercial for his product, or was it just me? First tech expert, book advertisement, him, his program. I get it. And maybe, and again, Mo, I say this in like every case. A lot of times jurors, once they start to kind of feel like one side is right, they start viewing the evidence through a lens of how that side wants you to view it. And I'm not saying like you're being duped or anything like that. A lot of juries do it. We know it as lawyers. That's why it's important to build momentum. You don't wait till the end to start bringing your best stuff. Opening statements are incredibly important. Guy's own tool, not CB, not many users, who's validated. Well, if it's really, junk science, I hope the defense experts can come up and hammer it. So we'll see. If he can't replicate it, it means she could have manually deleted it. That's what I felt, Tim. That's what I felt. Like I felt like he was much better on the how long to die in the cold than he was on the deletion part. Okay. On cross, Yannetti was very careful with this witness. I think it was appropriate. I think he did a good job because he said, you did this on iOS 15.8.2, not 15.2, whatever, which is what Jen McCabe had. He said that's true, but he thinks there's no difference. And he tried it on a bunch and it all worked the same. He said, if you were going to delete it, you would have to know what you were doing. And again, we know Matt McCabe worked in this type of stuff. So maybe that's what they're going to argue is he was able to do it. But he said basically that couldn't happen. And he thinks it's impossible basically that Jen McCabe deleted this, which I thought was very interesting. All right. Then we get to Nicholas Guarino, who is the Massachusetts State Police Officer, cell phone forensics. It's the last witness we're going to get to, only hopefully 10 or 15 minutes. And then we can see the fourth quarter of the Celtics game. Computer was mostly used by kids. Laptop was used by John. Nobody really accessed the Ring camera except on John's phone. He got cell phone extractions from John O'Keefe, Karen Reed, Jen McCabe, Kerry Roberts. Got stuff from Higgins' phone. Confirmed the screenshots were correct with the other phones. He thought the expert Green's report was wrong as well. And then here's the part everybody's been asking about. You guys tell me what you heard. It doesn't sound great to me. It's obviously not great if a witness is saying this in trial. But I've heard people say it sounded like something else to them. So we're going to play it. We're kind of going to leave it at that. If the witnesses are saying this on the stand, it's horrible. They shouldn't possibly be acting like this or saying things like this. So let's listen to it and I'll throw the comments up about what people think was said here. So, what do you think he said? Actually, don't type it in the chat. Don't type it in the chat. Yes, we're going to talk about this guy. It was a very weird time for him to say it. It's hard for me to fully feel like he said it. That's definitely what it sounded like to me in real time. I just think it's not great if witnesses are saying things like that. And unfortunately, the mic picked it up, and now that's what people are talking about. It's not great, obviously, in a death trial to say stuff like that, even if you're joking or feel bad or whatever. It happened in Crumbly as well. But then we finally get to these texts, okay? And these text messages, Paula said, I'm sorry to jump ahead. Well, I saved your comment, Paula. But you said the text messages will be Karen's undoing. I didn't say that. I said that's what I heard. I heard rumblings that this was the big bombshell. Did they sway you to the Commonwealth proving their case beyond a reasonable doubt? So I'm going to break them down here and we're going to discuss them together. So let's listen to these. Are texts or actually Facebook messages, whatever, which people think is weird. I kind of think that's weird. Between John O'Keefe and Karen Reed, the night or / day, all this happened, I think around 2 p.m. Let's get through them and see, what does this make us feel? I heard people saying on Twitter, we have the motive. Here's the motive. Now we know why she did it. She was so toxic and horrible. Obviously she did it and she did it on purpose. And here's the proof.
Great.
And now, Trooper Carino, do you recognize what's up on screen as the next image, sir? Just come on, I'm sorry. Can you scroll down just a little bit?
Yes.
Again, from this first page, if you could, the blue bubble is from Ms. Reed, is that correct?
Yes, that's correct.
And from Mr. O'Keefe, is that correct?
Yes.
And if you could, again, read from this first page as far as date, time, who was speaking, and what is it?
At 9:49 a.m., Karen says, "You've really hurt me this time." 10:02 a.m., "I'm sorry. This is, sorry, it's kind of read. I'm sorry, this has been an issue with me for 8 years. It physically hurts me to see everyone else in their life do things for them. And I'm forced to always be the bad guy."
So by the way, I took this to mean, and again, there's been a lot of talk about the kids. She spoiled them, whatever. He said, I'm sorry, this has been an issue for me for 8 years. It physically hurts me to see everyone else in their life do things for them. And I am forced to always be the bad guy. So I don't even know why I'm saying this. Like, I probably don't even need to say this. I don't even need to say this. Let's keep going. I think he's trying to help the kids. I think he's trying to do what's best for the kids. Let's leave it at that.
At 10:09 a.m., Karen says, "I am not the same as everybody else. Most of the time I try to do what is healthy / smart for them. More importantly, I try to support you and what you need. You just lashed out at me and said terrible things. I don't know how you've gone to this point with me, but I'm just trying to try my hardest. You made your point and continue to beat me down. I have a lot going on too. Physically, I'm falling apart and trying to get answers and help."
If I can stop you there, sir. If I can direct your attention to my apologies. Sir, if I can direct you to page 5.
Okay.
I'm sorry, bottom of page 4.
All right.
And starting with the blue bubble on the bottom of page 4, again, if you can indicate as to who's speaking, what is said, and the date and time.
Karen says to John at 1:21 p.m. on the 28th, "Maybe you can call someone."
So if you could continue on through page 5, sir.
On the 28th at 1:46 p.m., John says, "Like who?" On 1:47 p.m., "What time are you coming here?" And then there is, at 2:05, there's a message, but no content.
And the next message at 2:06, sir.
Yes, 2:06 from Karen. "I don't know what time. Feel kind of out of it. Just trying to clear my head." 2:06 p.m., John writes back, "Okay." 2:06 p.m. again. Karen says, "Text me later when you guys settle in later." Text me when you guys settle in later. John says, "Sure," at 2:06 p.m. again. Karen says at 2:16, "I feel pretty shitty about this. Feel pretty shitty about how this morning went down. I know you said sorry, but it really stung, especially when I've been trying pretty hard lately. I feel like a loser turning around, just coming back over after everything you said."
If I could ask you to continue on to page 7,
So
sir.
again, just to recap my thoughts so far, this feels like a normal fight. They yelled at each other. One of them feels worse than the other. They're going to talk about whether or not it's even worth continuing. In these text messages, it definitely seems like Karen Reed's the one holding on more than John O'Keefe. That's my read on it. She keeps like looking for validation and attention from him and like, tell me you like me, is kind of what it feels like, which this is 10 hours before she decides she wants to end his life. Like, I'm not catching that vibe so far.
Okay. At 2:17 p.m., John says, "Not sure what else you want me to do. I said I'm sorry and I was out of line. If you prefer to stay home, I totally get it." Karen replies back at 2:17, "Things in my own life have been difficult too, you know." John writes back at 2:17, I know. At 2:25 p.m., tell me if you're interested in someone else. Can't think of any other reason you've been like this. From Karen.
Okay, she's jealous. Fine. That's kind of come out a bunch in trial. It's proven by this Facebook message.
You could continue on page 8, sir.
At 2:25, John responds back, nope. Things
He says no, nobody else involved.
haven't been great between us for a while. Ever consider that? That was at 2:26. 2:29, he writes, kids are here, not in the mood to talk.
And how does the defendant respond to that at the bottom of page 8?
So you're not into it anymore. That's fine, but I don't want to keep trying, and you keep treating me like this. At 2:29 p.m.
If I could direct you to
It also kind of sounds like she's trying to get him to say it's over, and he's not saying it's over. Okay.
page 9.
Yep. Mr. Reed says, I'm trying to hug and kiss you this morning, and you whack me in the face with a pillow. At 2:29. At 2:30, she says, last night you're basically like, yeah, what about? When we talk about the future. So why don't you just admit you're not into it so much anymore? At 2:30, oh, sorry.
Go ahead.
I was at 2:30, John says, not how it went down, but okay.
Now, if Ms. Reed respond to that.
Again, seems like he's like kind of whatever about it, and she obviously keeps trying, and she keeps calling him. We'll talk about all the calls.
Please admit your head is out of the game with us.
If you could, sir, please continue on to top of page 10.
At 2:32 p.m., sick of always arguing and fighting. It's been weekly for several months now. So yeah, I'm not as quick to jump back into being lovey-dovey as you apparently. From John. And then John again at 2:32. Oh my God, stop calling.
Okay, stop you there for just a moment, sir. With regard to January 28th,
So instead of taking time for them to go through all the documents, she called him 18 times that day, 11 rejected, 4 missed, 3 answered. She keeps calling him even after he says stop. Eventually he calls her back, I think around 3:00. And then we get to more text. But yeah, she's calling him like crazy. Obviously she's mad. This is his girlfriend. I'm not going to, people of both genders can get a little wild and crazy in relationships sometimes and make a lot of calls and text and whatever. To me, she's not like, I mean, I've seen some of my buddies. Thank God I've never had a relationship like this. I've also been married since I was 22 years old and been dating my wife since I was 20. So not a lot of experience dating, but I've seen some horrible things come through in texts, like absolutely horrible. I wish you die, you POS, like horrible things. I didn't see any of that here. And it reminded me, some people were making comments like the McCabe's and all them when they had their phones and they were talking about those text messages, like make sure you tell them the guy didn't come in. If they didn't think these cell phones were ever going to get turned over, there wasn't like big conspiracy talk or code language like we've heard in some other trials in their phones either. So there's no smoking gun in any of their texts. There's some bad stuff. There's some bad stuff in Karen Reed, but hardly motive or a smoking gun. Am I wrong? Am I missing something about these texts that Amber said these are normal relationship discussions? They definitely skipped some connecting dots. I agree with you. I wonder if the defense is going to do that about how they went from fighting to they're going to hang out that night and where they're going to stay over the weekend. We're going to get to those texts now.
Trooper Green, I'm turning your attention.
Yes, so 2:32 p.m., she says, why would you start with me this morning? And then followed up by 2:33, you're setting me up to fail.
If I could turn your attention to page 11 and ask you to continue from there.
Ms. Reed says you started a number of fights from your end. John, and that's at 2:33. At 2:33, John writes back, I've explained it a few times already, not doing it again.
How does the defendant respond to that?
So you're not into this anymore. And then John says, not into fighting all the time, correct. That's at 2:34 p.m.
I mean, this literally sounds like such a dude. It's like, so you don't want me? And we're just like, well, I don't want to fight. It's like, I don't, can we not fight? If we don't fight, maybe it's cool. But if we're going to keep fighting.
If I could turn your attention to the top of the 12.
Yes, 2:34, Ms. Reed says, if you tell me you're interested in someone else, you will never hear from me again. You can have all the space in the world. John writes back, but there's no content at 2:34. And then at 2:34, she says, then stop starting with me.
How does Mr.
I mean, it just sounds like a fight at this point to me. Teresa, there was definitely some discrepancies between the two. Honestly, like it's hard for me with those experts. I liked the guy better than the girl. I actually liked the girl too. We'll see what the defense expert says, and I'll kind of figure out where I land after that, I guess.
Keep respond to that.
At 2:34, he writes back, I'm not answering, stop calling.
And if I could turn your attention to the top of page 13.
Ms. Reed says, can you please answer after how you treated me earlier? John responds back at 2:35, Kaylee is right here. Ms. Reed says, you're starting a rage with me out of nowhere, and then you tell me you're sick of fighting with me at 2:35. And she writes at 2:38, I'm going to grab a drink in a bit.
If I could direct you to the top of page 14, sir.
She says, can you answer please at 2:38? He writes back at 2:39, no, Karen, not sure why you need to announce that you're going drinking. Have fun.
Again, trying to make him jealous, maybe. Like, I'm going drinking. I don't know.
Karen writes back at 2:40, seeing if you want to meet me later. Can you please call me right after that?
And again, if I could direct you to the top of page 15.
John writes back at 2:40, have to take him to the doctor. He has practice. Sri writes back, yeah, 5 minutes. John writes back at 2:43, my father just walked in. Karen writes back, okay, can you please call me for 2 minutes at 2:44?
The top of page 16, sir.
2:44, John writes back, not right now. Karen writes back, I'm there when anyone else needs me at 2:44. 2:46, yes, John, you gave me utter grief this morning. I'd like you to call me for a minute.
And the last one from that page, sir.
Yeah, 2:47, I've been trying to get over the hump with is arguing, and now you tell me you're not into things. And if you don't want to fight weekly, but fly off the handle at 8 a.m. with me, like you're setting me up to fail.
Sir, if I could draw your attention to page 42.
So they jump from 16 to 42. I don't know why. If there's something important, I assume the defense is going to point it out to us. But the vibes kind of change from this fight to it's now 7:41, 2:42 to 7:41.
And sir, if I could ask you to start reading from the top of page 42.
At 7:41 p.m., Karen writes, okay, let me know if you end up leaving. John writes back at 7:42, why? Now you're not coming? Karen writes back, I'm waiting for the plumber. Actually think he's in the driveway, 7:42. John says 7:43, we're taking Mike's car, so I'm relying on you for a ride home if he leaves. Karen writes back at 7:43, he's not going home after. John writes back at 7:43, 8 on a Friday. He may have to get Michael. And you have a plumber coming over at 8. Knowing me and Papa could have handled it. Good luck. And that was at 7:44.
Thank you, sir. If I could direct your attention to page 49.
Jump again from 7:44 to 8:29 now.
If I could ask you to start from page 49, sir.
8:29 p.m. Yeah, but he lives right down the road. John writes back at 8:30. Karen, the storm is going to be intense. Can't drive. 8:30. She writes back, okay, well, if he can't, he can't. John writes back, I'll do it Monday. Karen responds at 8:31. I better not still have this problem on Monday. John writes back, plan on being there. Karen writes back at 8:32.
It sounds like he wants her to be at his house, right? He doesn't want her to be at her house. Again, reading into this, doesn't seem like tonight's the night I'm going to do it. I'm so mad at him.
I'd like to know, I can take a hot shower here if I need to. John writes back, figured you'd be in Kansas until Monday.
If I could direct you to the top of next page 51.
John, I'm getting off my phone. Let me know what you're doing. Karen writes back at 8:33. I think the four of us together is toxic to this relationship. Would like to limit it. And then says, you've said so yourself for probably a year now. And John writes back at 8:33. Blizzard tomorrow. Nobody is going anywhere.
Sir, if I could direct you to the top of page 52.
I don't know if she's talking about the four of them with the kids or other people. I'm not really sure, but it's pretty clear. He's like, you're just going to be at my house for the blizzard. It's safe there.
Okay. Karen says, maybe I'll come back late tonight. Bad snow is in the early AM. That's at 8:35. And again, 8:35. I'll head up there in a few minutes. Let me know if you leave. John replies back, sure. And then the next one's not until 12:55 AM on the 29th.
So 12:55 is, they said she hit him at 12:45. So if she texted him at 12:55, I'm going home. I don't really understand why. Is she setting up an alibi, or does she really think he's just at the Albert's house? I feel like either is plausible.
I'm going home.
And the I'm going home is from the defendant, 12:55 a.m. Is that correct?
Yes, that is correct.
And if I could direct your attention to the top of page 53.
Yes, 12:55 again. See you later. At 1:02, your kids are cooking alone. 1:29, 1:04 a.m.
All right.
And if I could direct your
So
attention to
these
the top
are some.
1:29.
Hold on. So these are some that people are saying is problematic. So I'm going home.
Yes, that is correct.
See you
And if I
later.
could direct your attention to the top of page 53.
Yes, 12:55 again. See you later. At 1:02, your kids are cooking alone. 1:29, 1:04 a.m. I'm back in Mansfield. The kids are home alone.
So I heard people saying this is a lie. This shows motive. This is so bad. She's so toxic. I agree. This isn't great. It's pretty toxic. It's not great girlfriend material. But how I read these is she wants him to come home. She wants attention. She's lying to him so that he gets home to be with the kids because she doesn't think he would get home to be with her. Now, it does kind of start to feel like maybe they are fighting at this point at 12:55, 1 o'clock, whatever. So did she leave fighting? It opens some doors, I think, for explanation. Hardly a bombshell, hardly a motive to me so far, though. Right? I don't know. I think she was just trying to get his attention, get him to come home, say she's not there, say the kids are alone because he'd be more likely to get there. Now, how is he supposed to get home without her? I don't know that answer. A lot of unanswered questions that, I don't really know what they're trying to do here. Audrey said, do you think they've proven manslaughter? So I think similar to the way that the defense has thrown out a burden to prove this conspiracy, I think the Commonwealth, the lesser included's there. We'll see how hard they argue it, but they have tried to go with intentional this whole time. And so that could hurt them as well. And if they start trying to say negligent or accident later, that could hurt. But I think if they should have gone manslaughter the whole time, accidental killing, and I think it would be a much different case. Margarita, why do you think Lally decided to move forward with the prosecution and trial considering this really bad investigation? It's impossible for me to answer. I have no clue. I don't know if he was forced to, if he's trying to make a name on this case. I have no idea. Sarah, with all the police effery, why didn't they get an outside expert that actually knows what they're talking about? Thanks, Peter. Maybe they couldn't. I don't know. Maybe they thought this guy was good enough after the grand jury. I don't know. Mags, you convinced me to apply at FSU Law once my undergrad is done. We'll update in a year or so. I'm on a break right now, but I'm 25. They say it's not too late. No, like one of my best friends and study partners was 32 when I was 22 in law school. It's definitely not too late. Karen D, can the defense make a statement in closing that all of things alleged don't have to be true to believe that some of them are true, or would that undermine their whole case? They got to be careful with just like throwing out stuff or saying like, oh, maybe this isn't true. It's no big deal. I think they'll say there was a cover up, but I think they'll say, even if you don't believe the cover up, there's reasonable doubt. Anne Marie, Peter, he doesn't even have an account for the truck, Brian Higgins' truck that was parked in the back and the curve in the road. You mean like on the accident reconstruction list? Because, the testimony he believes Brian Higgins' truck is gone at that point. Heather, question, Peter, do you think the state used the reconstruction expert they did because they couldn't find an actual expert that agreed with their theory? It was painful to watch. I think that's one plausible explanation, or maybe they thought he was good. Sandra, Commonwealth said in their opening that she hit him at 12:45, but then today they said between 12:20 and 12:30. So I thought they've said 12:30 to 12:45 the whole time. They definitely said 12:45 in their opening. But I don't know. Kathleen, if she's lying about being at his house after 1 a.m., doesn't that mean she still thinks he's alive? These texts definitely sound like somebody that thinks he's alive. That's what I was saying. These texts, if you would have gone for manslaughter or accidental killing, like she was so drunk she didn't even know she hit him, or maybe she knew she hit him and she didn't care because it was just a tap, whatever, that makes so much more sense than intentional. I can't get behind intentional. Gosh, we're almost at 2 hours. All right, there's only like a couple minutes left here, maybe 1 or 2 minutes, then we're done.
Thank you, sir. May I approach the retreat?
Yes. Can I see Councilor Sidebar about
that was it.
scheduling?
No, that was it. Okay, that was it. All right. So let me hit a couple more questions here. Welcome to all the new members. T. Shaw said, Peter, have you followed the Sunday ticket case? Not at all. Not at all. But somebody just sent me another sports case we'll take a look at. The Fast and the Curious, Lally is making a name for himself. It just might not be the name he wanted. Ooh, touche. June said, Peter, tonight is a night would be first degree. Oh, yeah. I'm saying it doesn't seem like those emotions have started to build up. It seems like they were mad at each other. They fought, but there's no real anger or resentment. A lot of times you can see that in texts beforehand, even if there's no plan or premeditation, but I get what you're saying. Leilani, I'm sorry if I missed it. When is the state supposed to rest their case? They still have 2 or 3 more witnesses, I think. It was supposed to be tomorrow. It's not going to be tomorrow. Friday, I guess, maybe. I don't know. And welcome, Lauren. All right, that's all we got. 2 hours. Please hit that like button. Please subscribe. You guys are the best. We're going to continue bringing it. If the voir dire is streamed tomorrow, which I think it is, we'll break it down at night, give our reaction after it ends at some point. Wednesday is off for this case. We got another YSL video coming with my dad for more updates on that, which has just been absolutely insane. You guys are the best. I appreciate you so much. Thank you for your comments. Thank you for your questions. I got to get out of here. Till next time. Oh, Netwoman just drops a 50 bagger on the way out. So make sure you guys have the gifting memberships turned on, because 50 of you in here are going to be new members. We're doing our members only live, I think, either this week or next week for June. So if you're a member, get ready for that. Thank you guys for joining me. Until next time, I am out of here. thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a page you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.